Legal Tuesday, where I'm going to go through your workplace rights. This week we're going to go through a hot topic, reasonable adjustments. Let's clear the confusion up, because some of you think just because you request it you are entitled to it, and that's not the case. Reasonable adjustments don't just mean that the employer has to remove your disadvantage from the workplace. It means it is reasonable for everybody. Otherwise, this isn't just about your employer doing you a favour, it is also a legal right if it is reasonable for everybody. Some examples of reasonable adjustments could be things like providing assistive technology, flexible working, or modifying tasks. But it wouldn't be a reasonable adjustment if you asked for a technology that your company couldn't enforce. So if you worked in a highly secure environment and you asked for access to ChatGPT, the access is going to be probably no, because of the security concerns, be something that the company could reasonably reject. Because someone in your team has the same condition as you doesn't mean that you will necessarily get the same reasonable adjustments. Because the whole point of reasonable adjustments is they are specific to you and your role. We all know that people can have the same conditions and they can impact them differently, which is the whole reason why they are completely bespoke to you. You'll often end up with a referral to occupational health when you're asking for reasonable adjustments, and that should be the right thing for employers to do. It's considered best practice. You need to be specific about what is going to be important to you and what is going to help you in the workplace. So I know someone that asked for the agenda for their work meeting to be sent out 24 hours in advance. It turned out that the company started not sending it out in advance because they considered that the meeting was the same every week. The person involved, the meeting wasn't the same every week, because sometimes the order in which people were speaking was different, or sometimes ad hoc things came up in the meeting. And they then found that to be really distressing, and that was part of the reasonable adjustment, was that they needed to know what was coming up, the order in which people were speaking, when they were expected to be speaking. That was something that they considered as part of their reasonable adjustment. But because they weren't clear to their employer, the employer didn't understand, and for them there wasn't really a massive change in the agenda, so they didn't feel the need to send it out. You need to be very specific about precisely what you need and how that's going to help you, so that your employer knows exactly what they need to do to help you. You can make requests in writing or verbally for reasonable adjustments. It's better to do it in writing so that you've got an audit trail, especially when those things get declined or your company takes too long to process them. But also check your own company's policies on how they handle reasonable adjustments. And if you're in any doubt, there are people that you can reach out to, such as ACAS. If a company offers access to an employee assistance program, they can also be a great place to go to get resources and help.